for joining me. As you know, I just did number 5 for the EBRE segments that I'm doing, and trying to keep this stuff fresh in my mind. And I was thinking about the exceptions to the parole evidence rule, and I hadn't watched Emerson, this video by him in a while, but I watched it a long time ago. And I watched again, and I was like, voila. So basically, I just read off, now if you haven't watched this, I just read off an EBR 5, which is right before this. It should be in the playlist in the order it's posted. So this is going to be number 6, and I'm going to try to make it quick because I really have a lot on my plate. But I just was thinking to myself, why the heck the people that wrote the answers that were selected by the bar as the better answers missed completely this. And Emerson did not miss it. Obviously, he's a very intelligent person. And basically, he says, look, this is fraud. Fraud's a misrepresentation. He says it right off the top of his head. I mean, at the beginning of this video. It's 5 minutes in. He goes, I'm going to list them. I'm going to list all the elements of fraud. Now, when you have a case, you can bring a case to court as a contract case. You can bring it as a tort case. It's a crossover. Now, the rules for torts are a little bit different than the rules for contracts. For example, punitive damages are allowed with torts, but not with contracts, right? I'm pretty sure that's it. I got to double check just to, like I said, I'm trying to keep this stuff fresh in my mind. If you don't use it, you lose it, right? So anyway, I did a live stream of it, and I sort of commented on the essays as I was seeing them, and I was thinking to myself, both of them seemed kind of, I don't know. It seemed like they were thinking property law, and actually, after I got off, I looked at the law for riparian rights or water rights. I found some legal stuff on that, and a 2020 law with the EPA, and I decided not to post that. And then I went back and I looked at the essay again, and then I looked at what Emerson wrote, and I was like, okay, wait, there's 7 exceptions to the parole evidence, right? And so I just Googled this and found this article. And right here, this is by Thomson Reuters. And it says, in this post, we'll be going through the exceptions to the parole evidence rule. First, by the way, it's not parole, it's parole. And I think, I forget who the contracts attorney that was telling me about this pronunciation, but this is, my dad's an attorney too. It's kind of like, if you look at the word parole, it has an E at the end, except for when you're talking about the parole evidence rule. So just, a lot of people by mistake pronounce it wrong. But anyway, this is the list of the exceptions to this rule, okay, under which evidence normally excluded by the parole evidence can be admitted. Now, what is the parole evidence rule? It means that normally they want to look at the 4 corners of the contract, right? And they don't want you adding a bunch of stuff in. But if there's a mistake or an ambiguity to clarify the contract, they're going to let it in, right? So here's the whole list. To resolve ambiguities in a contract, assist in interpreting a term in the contract, something that wasn't clear, to show that a term in the contract is a mistake, to show that fraud, duress, unconscionable behavior, or torturous interference with the contract has occurred, or to show that consideration was never paid, or to identify the parties and subject matter of the contract, to modify the contract after it's been signed by all the parties, to show a condition that had occurred before the contract performance was due. Let's say you were going to buy timber land, and for the purpose of well, let's say you were going to buy a maple farm that had maple trees, and you're going to tap the maple every spring, and there was a fire over the summer due to a drought, and the contract was supposed to close in the fall, but in between all the trees burned down, and you were supposed to have the attached trees that run with the land, and they're gone, and the purpose of it was to have a maple outfit. So maybe the landowner would sue you to perform, and you would say, well, wait a minute, it's impossible, I'm excused because all the trees burned down. But anyway, so I'm just using an example off the top of my head. I'm not like totally sure, but so to show that an implied term of a custom or trait of use, past dealings, is part of the contract, even if it's not written in the contract. If evidence is incorporated into the contract by reference to the evidence in the contract itself. So, but basically, reconsidering the fraud exception to the parol evidence rule. It says a 75-year-old decision, Supreme Court ruled that the parol evidence rule does not exclude evidence of allegedly false promises. So there's a lot of writing on this, and it's, it's common law. Look at this, 2003, California Supreme Court clarifies, broadens fraud exception. So, if you're going to be a top-notch attorney, you're not going to just give off an answer that's going to just pass and give you 75. You're going to go the extra yard. You're going to do the extra research, and you're going to give the right answer. And you're going to get more points. You'll get an 85 or a 90, right? So you look up the law, and you listen, you review, and then, when people on either side are splitting hairs and citing the rules, here's Cornell law. So the agreement's made outside of court. It says normally, the rule bars extrinsic evidence, right? Including prior contemporaneous oral agreements and prior contemporaneous written agreements that contradict or create a variation of a term in writing that the parties intended to be completely integrated. In other words, any information leading up to or during a contract that is not included in the writing is considered inadmissible evidence and is excluded from the jury. The jury will therefore only look at it. Now, the parol evidence rule is also codified in UCC 2202. So it works for both common law and for UCC with contracts. And so just remember that it says contract disputes. Parol evidence is any agreement that is not contained within the written contract. Under the parol evidence rule, these agreements made outside of the contract are inadmissible in court unless there's evidence of fraud, duress, or mutual mistake. Now, some other bar review companies might say things like ambiguity. Okay, it means that it's not clear. So they'll let stuff in that's, a unilateral mistake, a bilateral mistake, different ambiguities. So I remember this when I took evidence law. I remember sitting down reading like 13 exceptions to the hearsay rule. It was like, well, wait a minute. So that hearsay, oh, objection, hearsay. Well, that you hear that all the time. Well, there's like a whole bunch of exceptions to it, and it's like people are like, I remember people were saying stuff about how did they get this information? What about attorney-client privilege? Well, there's an exception to that, right? There's an exception. Look up the exceptions because a lot of times people will memorize the main rule, then they'll read the fact pattern, and they will not spot this stuff. Now, since it's a contracts question, you answer the call of the question, right? Now, I want to recommend a book that I have, and I had the CDs too, way back in the day. And it's by Dr. Mary Campbell. She's a PhD, I think, in linguistics or something. And I get some of my ideas, not just from there's no new ideas, right? It's called Scoring High on Bar Exam Essays. It's a short book. It's like it's not that big. It's like a regular, here's the book. Yes, I like this book. Okay, now this shows different states in the United States, and she's taken many of them, and she also has like audios. It's on audio, so you don't have to read everything cover to cover, but it really would help if you read the book with it. Now, she has a PhD, okay? She's not just a JD, she's a JD and a PhD. It's an older book. Now, this is one of the things I noticed about the older people that do the law. Nothing personal. But they used to go to the library when they had those catalog things, and they wrote their essays before there was the computer to look it up, and they spent hours and hours and hours in the library like a hermit. Now we have the internet, everything's at our fingertip, but she breaks it down on how to do it too. But Emerson's giving examples. That's what how he's teaching it. This is free. He's donated to the public. I'm just kind of like doing a little bit of extra to go with it and reviewing it. I got to keep this stuff fresh in my mind because I'm working on a PhD, and I want to go back and finish this up. So anyway, that's where I'm at. And I wanted to let you know that when you read the essay answers, try to think, okay, these are two passing answers, right? But could it have been done even better, right? Good, better, best. Never let it rest till your good gets better and your better gets best, right? Now, you can take the bar as many times as you want. You can take the baby bar as many times as you want. But sometimes, how much do you want it, right? How much do you want? How much time do you have? How practical is it? You got to do a lot of studying. Don't be too hard on yourself. And, if at first you don't succeed, try again, right? Well, it's up to you what you want to do. But I just thought I'd throw this out here about the fact that, you'll have crossover cases. The call of the question in this, I don't have it open right now, but the call of the question in that was asking you two questions. Actually, I have the paper. Hold on a second. Let me grab the paper. I had it printed up, right? And I have a scanner. Well, if you have an iPhone, in Notes you can scan documents to PDF, and then you can upload them. But you can also print. So anyway, I'm not going to go through a lesson on that, but the call of the question in this, let me read it. The call of the question was, what equitable and contractual remedies, if any, can Barb seek? Okay, so they're putting it on, the first question is, what can Barb seek? Right? She wants the land to develop. And then it says, it's a compound question. And then what defenses, if any, can Stan assert? So what he's saying in here, Emerson, is he's like, if you don't read this carefully, you're probably going to miss it because it's very subtle. And what is that? Stan is going to assert that she committed fraud through an omission by a misrepresentation because he was conditioning the sale on the land being kept as farmland. Okay? So that's the reasoning. Now, when you do an essay, you have to, there's so many points in the essay based on what issues you hit and how you can show your logical reasoning, how you apply the law. And yes, the attorneys that grade these know that there's differing opinions. Now, the attorneys in California have to pass the bar in California, and California has higher standards than most states. So it's not going to be a C lawyer, it's going to be a B lawyer. And what do I mean by B? I mean probably closer to 80%. Okay? So if they missed 2 main points, but they got everything else, okay, well, it was subtle, it wasn't obvious, it was kind of snuck in there, and, sometimes things are subject to argument. But anyway, he does kind of go off on the fraud elements as well, because he sees it as a crossover. And basically, as a lawyer, you can know, hey, well, the statute of limitations in most states for torts is 2 years. But with contracts, it might be a little bit longer. So it just depends. Anyway, I just wanted to jump on here. I got kind of a aha moment. And I was scratching my head on those answers that were the model answers. And I guess, he doesn't read off the model answers because he's so intelligent, he can figure out what they're looking for. And that, hey, yeah, maybe they got 70% of what, and that was the best answers because most of the people that took it didn't get it, and that's probably why they retired the question. I don't know. But anyway, thanks for listening. Take care. Bye.